I think we should be careful of mandating that the solution is the same for everyone, but instead maybe be more thoughtful about what solutions work best in what types of places, and that the best solution in Atlanta might not be the best solution for rural Georgia.
Today on Law Next, a report from the American Bar Association in August portrayed our nation's legal deserts, large swaths of the country in which there are few or no lawyers. That report followed from a 2018 paper on legal deserts that was published in the Harvard Law and Policy Review. My guest today is one of the authors of that paper, Lauren Sudeall, Associate Professor of Law and founding faculty director of the Center for Access to Justice at Georgia State University College of Law. We're going to talk about legal deserts and about Sudeall's other research in which she focuses on access to the courts in both the civil and criminal contexts, and how lower-income individuals navigate the legal system either with or without the help of a lawyer. This is Bob Ambrogi, and you're listening to Law Next, the podcast that features the innovators and entrepreneurs who are driving what's next in law. We'll get to today's interview in just a moment, but first, let's hear from the sponsors who generously support Law Next. Case, the leading practice management solution specifically tailored for workers' comp, criminal law, personal injury, and employment and labor law firms. Case just announced a robust integration with DocuSign, the legal industry's most trusted e-signature provider. You can keep tabs on the entire signature process right from Case, saving your firm and your clients time, money, and peace of mind. To learn more about Case, visit it at meruscase.com. That's MERUSCASE.com. Let me also give a quick shout out to our top supporter on Patreon, Alan Rodriguez, the CEO of the legal marketing and digital innovation company 1400.com. Listeners, if you'd like to support us on Patreon, go to patreon.com/lawnext. And now, on to this week's interview. Lauren Sudeall, welcome to Law Next.
Thank you. Thank you so much for having me here, I guess virtually.
Yeah, it's good to talk to you. I hope you're doing okay during these crazy times we all find ourselves in.
I am hanging in there. It's a challenge, but there are challenges everywhere. So I'm glad to be doing what I get to do.
Yeah, we're all facing challenges. So, if I may ask you, I mean, your background, you're a Yale undergrad, Harvard Law School. You clerked for Justice John Paul Stevens at the Supreme Court. How did you come to develop your interest and your focus on access to justice issues?
I think, I've always been drawn to doing work in the public interest. I knew when I went to law school that was what I wanted to do, but it took me a little while, as it does many law students, to figure out exactly where I wanted to focus. And I started my 1L summer with an internship at the Southern Center for Human Rights here in Atlanta, which is where I ended up going to work after my clerkships. And I think that experience was really powerful. I got to work on death penalty case that summer. And when I went to work at the Southern Center, I did both capital work, but also work around the right to counsel. So suing the state for not providing counsel where it should have been. And I think that just gave me a lot of really interesting perspective on the system and where the system is failing. So when I decided to leave practice and going to teaching, I wanted to stay in the South working on similar issues. And that's what I did. When I got to Georgia State, after a few years, I founded the center. And then over time, realized, although my practice experience had been in the criminal area, there were a whole host of issues, both similar and different on the civil side, the common thread being that a lot of people don't have equal access in many different ways, and sort of thinking a lot about how different the experience and understanding of the legal system is for a lot of those folks. And so that's where I've tried to focus my time and my research.
What was it about working in the South that made you want to continue your career there?
It's funny. I'm not from the South. I'm from outside of Boston, and I've spent time in a lot of big cities, which is also funny. I think that I've ended up also focusing on rural justice because it's really not a part of my background. I think most people who end up working in that area are from those places. But I think, part of why I came to work here originally was just a feeling that while there are problems across the country, the magnitude of some of those problems just seemed greater in the South. It's an area with really high poverty rates, few resources, a lot of other dynamics geographically, politically, whatnot, that just make, I think, for a tough situation for a lot of defendants on the criminal side and a lot of plaintiffs or litigants on the civil side. And so I think just sort of seeing, I always joke that when you look at a map of the country on any given sort of social issue, one area of the country always seems to be sort of going in a different direction or all a different color, or the color always seems deeper there. And I guess I was just really drawn to that. It felt like where the help was, or where the work was needed. A lot of my friends from law school, unsurprisingly, went to places like New York and DC and
Right.
California. And I just felt like, again, while there are a lot of issues and everywhere, there was a real need for people to work here. And I think Stephen Bright, who used to be the executive director of the Southern Center, both worked there when I went there and also was a teacher of mine at Harvard. And so I think he was also a personal inspiration for why it was so important to come here to do this work.
And you are as you said, you are the founding faculty director of the Center for Access to Justice. What is the Center for Access to Justice? What is your focus? What do you do?
Well, you touched on part of it in your introduction. I think the idea behind the center is to focus on how lower income individuals and just marginalized individuals more generally interact with and experience the legal system, as you said, both on the civil and criminal sides, with a focus on this part of the country. And, I had a real desire to create sort of a space within the university to think about these issues and to bring the resources of the university to bear on these issues. When I went into academia, I did so with the idea that I really wanted to remain rooted in real world issues, things going on in the community, and really do research that had an impact. And I felt like the center would be a good vehicle to do that, and also to provide ways for students to become engaged in that sort of thing. We have educational pieces, we do a lot of programming. We started a pro bono program so students can start, engaging with that type of work early on. And all of it has been, fortunately, really successful, which has been great. And I think part of the motivation was also related to my personal motivation to coming to this part of the country, which was that I would go to these national conferences and hear people talking about reform and work going on in other parts of the country. And I would always find myself making friends with the person from Mississippi or Alabama because we could relate to one another and sort of to the challenges that we were facing. And I wanted to provide sort of a home for people, practitioners, policymakers, people engaging with these issues, to come and talk about how those issues are playing out in this part of the country, which often is very different, and what's possible feels different in this part of the country than elsewhere.
Yeah. And so the center is not just research focused. There's a practical component or a practice component to it as well.
Yeah, we're not a clinic, and people often get that piece confused. But I think about what we do in three buckets. So the first area is sort of serving as a convener, so bringing people together both within and from outside of the university. The second being the research piece, which I know we'll talk about more. And the third being focused on education and students. So that's where we have a certificate in public interest law and policy. We offer related courses. The pro bono program is housed there, where we offer discrete opportunities for students, but also an alternative spring break where they can spend their spring break immersed in a substantive area of law, and giving back in that area. So there's been a number of different things that have spun off, but those are the three major things that we do.
So I want to talk about this issue of legal deserts. The ABA, as I said, in their 2020 profile of the legal profession that was released, I guess late July, for the first time ever in that. Well, I think it's only the second year they did the profile, but this year they included a section on legal deserts where they painted a picture of the fact that there are large areas of this country, mostly rural, or probably primarily rural, in which there are few or no lawyers. The ABA report said that of the 3,100 counties in the country, 54 do not have a single lawyer in them, and another 82 have just one or two lawyers. And that kind of profile that they put together was followed on this paper that you contributed to back in 2018, entitled Legal Deserts, a multi-state perspective on rural access to justice, in which Lisa Pruitt, a law professor at UC Davis, was the lead author, I guess, and it was published in the Harvard Law and Policy Review. You, in particular, in that paper, focused on the issues in Georgia. But can you draw a sort of a broad picture for us of what do we mean by legal deserts? What are we talking about here, and what's the problem they pose?
So, I mean, I think, it's really just what you said, which is that it's areas, in some cases, very large areas where there are no lawyers or, in practice, very few lawyers, especially lawyers that can actually take on the legal needs that are present in that community. I think in the ABA report, and certainly in our article, we talk about even when there are lawyers, right, it could often mean that there's a prosecutor and somebody who's a judge and maybe defense attorney. So those aren't people that can help, the average resident in those counties with the legal issues they may have in the civil sphere, for example, or other needs they have. In Georgia, and this is in the article, of course, there are, at least as of the last time I looked, there were 5 counties that had no lawyers, but another 59 counties, I believe, that had 10 or fewer. So that means that, even if you're in one county that has no lawyer, there may not be many for several counties around you. In Georgia, we have an extraordinarily high number of counties. We have 159 counties. So they're maybe a little smaller, but still that means a lot. And, why does that matter? I think it matters for a lot of reasons. One, as on a basic level, people just don't have lawyers to address the needs they have. You have to sort of layer onto that. And I know you've had Becky Sandifer on your podcast, and she, does a lot with this, but a lot of people don't recognize they have a legal need. And even if they do, they don't always know how to address it. But I think when you don't have lawyers as part of the fabric and in some ways part of the culture, it's probably going to be even more the case that people don't understand what lawyers do and what value they add. I know that's been my experience in doing some of the research I've done where I've talked to people, doing research on eviction court. Both landlords and tenants don't really see the need, right? Or don't really some of them don't really understand how a lawyer can help. And I think that maybe changes in, it's not all about rural urban, but I think in big cities, a lot of people think to go to a lawyer right away when something comes up, whereas I think folks don't have the same instinct. And also, right, on the criminal side, there are distinct issues. If people don't have lawyers, that can lead directly to things like increased rates of pretrial detention, which in the context of COVID, right, is actually really dangerous and creates real risk for people. So I think there are all sorts of reasons why it matters, both sort of very practical, like the pretrial incarceration piece, but also the less tangible, maybe in the ways that it sort of influences how people think about addressing the problems they have and the resources that may or may not be available to them.
Yeah. One of the aspects of the ABA report this summer that was so interesting was, I think that, I think if you talk about if you were to talk to somebody who's familiar with the legal profession about legal deserts, it wouldn't surprise them perhaps that areas of maybe of the South or of the Midwest would have legal deserts. But what was kind of dramatic about this report was the extent to which states with fairly heavy populations of lawyers still have legal deserts. I mean, California and New York, for example, have areas of the state where there are very few lawyers. It's a problem, I think, that is that people don't think about, or maybe it's one of those problems of it ain't going to happen here, but it happens somewhere else. What does it look like in Georgia? I mean, how much of the population lives in rural areas? What does that population look like?
So, like a lot of those other states, and if you look at any of the maps in the ABA report, you see a pattern, which is that there's a cluster. We have a map on our website, on the center's website, where we drill down into a lot of different data points relating to access to justice and map them on Georgia. And you can see that most of the lawyers in Georgia are clustered around Atlanta. I can't remember the number off the top of my head, but I think it's something like maybe 40% of the lawyers in Georgia are maybe is in Fulton County, which is the county where the Capitol is located. So very, very concentrated. And once you get outside of that area, the numbers just drop. One thing that I talk about in the article that is unique about Georgia is that, I think when people think about rural America, they often think about white America, right?
Right.
And that is not true in a lot of different places and for different reasons. But in Georgia, one thing that's unique is that the rural population is more than 25% African American, right? So when we think about who this is impacting, it's not just impacting white Americans, or it's not this right sort of homogeneous group. It's actually a very diverse group of people in many different ways. You have counties bordering Alabama that are largely Black. You also have counties bordering Florida that are heavily Latinx and may have language access issues as well. So one of the points that I've been making recently and talking to folks about rural justice is that another mistake we should be careful of making is not generalizing about rural areas, much in the same way we shouldn't generalize about any other areas. Rural counties all have their own needs, their own demographics. And so while there are some trends that are true of rural America, there are also ways in which things are very different. And the other point I just wanted to make quickly is that, while you were speaking, I was thinking about how I think we have a bias when we talk about a lot of these issues. You said that people aren't aware, which I agree with, that California has these large parts of the state that are very different from what we think of, right? People think about San Francisco and LA or wine country. And by people, I
Right.
mean people from other cities in the country. But so I think we don't even realize sometimes that we're leaving a lot of people out of this conversation, right? When we think about access to justice, when you go to these workshops or conferences and people are talking about ways to fix problems, about technology and all of these other things we can do, I think that's leaving a lot of people out of the equation. I'm thinking about what is going to work for them, what do they want, what's feasible. The last data point I'll give here is, I've been doing a lot of work in the eviction space, and one statistic people often give is, in eviction court, 90% of landlords are represented while 10% of tenants are represented.
Mm-hmm.
And I hear that statistic over and over again.
Yeah.
That is true of big cities.
Yeah, that's true in
Outside of
Boston.
big cities, right? But outside of big cities, there are plenty of issues, but that figure in the research that we've done, less than 1% of tenants are represented, but even landlords are not that well represented, maybe
Mm-hmm.
in 10, 12% of cases. So you're just talking about large areas where lawyers on any side are really just not a big part of the equation.
Yeah. And I mean, you alluded to a couple of things in what you were just saying. One is the technology issue. And yeah, there's certainly been a lot of talk about technology as potentially a way of dealing with this access to justice issue in rural areas. I mean, I know the Legal Services Corporation's legal tech report that came out, 5 years or so ago, talked about the need for legal help portals and greater use of video conferencing and other forms of delivering legal services in order to reach people in more geographically remote areas. But what are the issues that we're not understanding about that? Are there some?
Well, I think often there's lip surface. People, I think, are starting to acknowledge they have to at least drop a footnote and say this might not work everywhere, but we haven't really sort of brought it into the center of the discussion. And I think there's two pieces. One is just sort of the feasibility issue, right? Do a lot of these areas have the infrastructure to actually have internet-based solutions? Do people in those communities have the tools they need to even take advantage of them?
Right.
Right? I think in this time, especially with COVID, a lot of these issues have come up because we're doing everything virtually. So you've probably seen some of the articles talking about how families or students are camping out in parking lots or trying to go near their school building just to get internet because they can't go to school. They can't do things. So I think there's one issue is, do they even have access, literally? But I also think there's another piece, which is cultural, which is how are people used to getting information and where are they looking, right? I think again, I use we in the way I probably should, thinking about people, in big cities, people, who are, I think, maybe also highly educated. As soon as I want to find anything, I go to the internet, right? That is
Right.
not how everybody thinks and how everyone is oriented. I think a lot of the people that I've spoken to in some of these areas, they get all their information by word of mouth.
Hmm.
right? And so I think we have to be smart about putting things out there, both that people can actually use, but that people are going to think to use and going to want to use.
Right. And as you say, there are issues with regard to access to broadband. I mean,
Mhm.
surprisingly, in Massachusetts, there are issues with regard to broadband, let alone rural areas of Georgia. There are large swaths of Western Massachusetts that do not have broadband access, surprisingly.
Right.
And then there is the whole issue of technological literacy. I mean, it's not just a matter of thinking to use Google, but of even knowing how to use Google or knowing
Right.
how to use the internet to find certain kinds of information, which I assume is going to be a real issue for any number of populations in the United States, particularly older populations, perhaps,
Hmm.
and certainly some minorities. Um, One of the issues that you talk about in your section of that article from 2018 is the problem of lawyers aging out and there
Hmm.
being nobody to replace them. Older lawyers retiring and younger lawyers there not being younger lawyers in a community is part of the answer to this to find ways to entice younger lawyers to set up shop in rural areas.
I think that is definitely a big part of it because, right, there are some things for which you're always going to need a lawyer, and I think there are programs across the country that have tried to do this with mixed success. Some of them are in that article I read, recently about some others. I think the program in South Dakota has been successful. In Georgia, we have not really. There have been little efforts here and there, no sort of real statewide push. I do think we need more lawyers in part because the research has shown it's a little more nuanced than lawyers might want you to think. But the research has shown that lawyers make a difference in all sorts of ways. But I also think there are a lot of ways that non-lawyers can make a difference. I know this is something that Becky Sandiford talks about as well.
Yeah.
Right? There are things that I don't know that you really need to be a lawyer to do that would still make a really big difference. And in Georgia, there's been a lot of hesitation, thinking more expansively about the options that we might put forth to allow people to be more engaged in providing assistance without violating certain professional and ethical rules. But I think the answer is not just more lawyers, because I tend to think that there are never going to be enough lawyers to address every need that comes up in every county across the state or across the country. So I
Right.
think we have to think more creatively, both about who else can help and sort of thinking outside the mold, right? I think another movement has been thinking about, right, where do people go and where do they look for help? Right? So people don't necessarily seek out legal aid. Most people don't know what legal aid is, but they do go to school, they go to church, they go to hospitals when they're sick, right? So why don't we put resources in those places, sometimes lawyers, but also others, to help people both see that what they're dealing with is actually a legal issue, and help them figure out how to address that. I think that's part of it. Um, and I also think the last piece is actually just changing the system, right? We've sort of designed a system, largely lawyers have designed a system that is designed for lawyers, right? So in part because that makes sense, right? If you're thinking in a protectionist way about the profession, that's
Right.
job security. But I think we actually need to change the system itself so that having a lawyer in some cases is maybe not critical to be able to use the system effectively. So changing the way we think about how it's structured, changing some of the way that we talk, right? Not using legal language, um, thinking about not making it so impenetrable to people who don't have that kind of training. I think that's a big part of it too.
Yeah. So does it follow from what you just said that you support efforts around the country to loosen regulatory restrictions in the legal profession and allow perhaps others than licensed lawyers to deliver legal services?
I do. One of my favorite lines that I think I came up with a few years ago is that lawyers don't have a monopoly on justice, right? I think justice is really important to a lot of us, and we're really proud of ourselves, and we play a huge role. But we can't fix the problem ourselves. So it's sort of naive to think that we should even try to. So I think, yeah, I do support that. I think we have to be smart about it, and I don't think we want people willy nilly running all over the place offering up legal assistance, that could get dangerous and probably hurt a lot of people. But I think that there are ways to do it that are smart, and I think that there are examples of that, and there are also examples of maybe things that haven't proven successful. But I think we're only going to get there through some trial and error.
We'll get back to my interview in just a moment, but first, let's take a break to hear from the sponsors who generously support Law Next. We want to thank our sponsor, ASG Legal Tech, the company behind the legal industry's 4 most leading software solutions: the practice management platforms Practice Panther, Bill for Time, in Maris case, and e-payments platform Headnote. Now, let's get back to this week's interview. So you just mentioned this concept of thinking about where people go for help, and thinking about, well, could somehow you partner with, say, places of worship to deliver legal services. Are there examples of this in Georgia or elsewhere that you know of where legal services are being made available to people in what might seem unconventional ways?
There are. So there's a program that's run through the Atlanta Volunteer Lawyers Foundation here in Atlanta that puts lawyers and community advocates in schools. And I think the idea behind that was that there are certain neighborhoods where there are really high eviction rates, and that was causing turnover in the schools, which has negative impacts on children and their ability to sort of succeed educationally. And from my understanding, that program has been really successful in part because I think what it does is it creates a basis for trust, or it creates those relationships. So people know this is not just a faceless entity or source for help that's sort of abstract, but instead it's people that are known within the community. On the places of worship front, I know that there's a program in Tennessee, and I think I also recently heard of one in North Carolina. With those programs, and at least I think the idea behind the one in Tennessee was that they were going to train religious leaders to be able to identify when someone comes to them with a problem that, that problem might be a legal issue or maybe could benefit from legal assistance. And I think in some form, maybe even use members of the congregation to help provide that assistance pro bono. I don't know. I've not really seen, and it might be out there. I just don't know whether there have been successes out of that program. But I think certainly the idea is a good one. Sort of thinking about the people, the ways in which these issues are going to come up more organically, and sort of the times that people may express a need for help, and then trying to pair that with just having the resources available in that moment or in that space, as opposed to expecting someone who's already extremely stressed out and having a difficult time to, in that moment, think, oh, you know what, I should contact legal aid, when they've never even heard of legal aid before.
Right. Yeah. You're at a law school. What is there a role for law schools to play in enhancing the delivery of legal services in rural communities?
Definitely, I think there is, and we've tried to do some. Ironically, we are in Atlanta, so
Yeah.
with all the other lawyers,
Right.
so we are not in the best position as a law school, but we do the alternative spring break trip I mentioned. We've had different iterations of it in different substantive areas, but we've had a rural justice trip. So we've sent students to different parts of the state to sort of understand better what the legal system looks like there, meet some of the people, see what their experience is like. We're in the process of developing, it may have even started, the rural externship program, where we try to address what you were talking about earlier, right? This idea that people the bar is graying and there are no lawyers to replace them. And some of the concerns that I think students understandably have about, am I going to go to this area and not have anybody to mentor me? How am I going to make a living? How am I, I think law practices work very differently in different parts of the state. And so I think the idea there is to sort of also match students up with lawyers so they can get a better sense of what this will look like. So it's not an abstract idea, and maybe what some of the positive sides of that are. Another thing that Georgia State, I think, has been really sensitive to is that a lot of our students do go to small firms or start their own shop. And so thinking about how to teach students about the business of law, or there are a lot of things that you have to know in opening up your own law practice that you don't learn in law school. And so trying to give students some of those tools, which of course, would be really helpful if you're going to go into a smaller county and either start your own practice or work in a very, very small practice. But I think one of the other problems that we have as law schools is that we don't teach students to be generalists or to practice in a lot of areas. Obviously, you don't have to choose a major in law school, but I think we do tend to funnel students into a specialization. Or from the beginning of law school, we say, what do you want to do? We want them to sort of pick an area, instead of giving them a sense of, or even practical experience in a lot of different areas, which is often what a lot of small town lawyers need.
Yep. Was it, I'm trying to remember now whether it was in Georgia from that article that there was a proposal or legislative proposal put forth to provide some tuition debt relief for law students who would be willing to go into rural areas after graduation. Is that right?
There was a proposal, but it didn't
Yeah,
succeed.
it didn't succeed.
So I know that in other places they've had different luck.
I know that you've been, as you mentioned earlier, you've been doing research more recently on what's been happening in eviction courts in rural Georgia, especially in recent months. I'm not sure to what extent your research has been able to look at kind of where we are currently in the midst of this pandemic, but do you have a sense, what have you seen in terms of how the pandemic has either has exacerbated or not the access to justice issues faced by those in rural areas?
So I think, I've done both some really in-depth research on how dispossessory court, which is what we call eviction court here in Georgia, operates in rural and suburban counties. But that was over a 5-year period pre-pandemic.
Yeah.
But I also have been fortunate to work with my colleague, Dan Pasciuti, who's in the sociology department, who we partnered together on that research. We have been working with Georgia Appleseed on some data that they've collected around how courts have been responding to the pandemic, and magistrate courts in particular, which are the courts that typically handle evictions in Georgia. And I think it's interesting. I think the overall takeaway is maybe not a substantive takeaway, but I still think it's important, which is that there's incredible variation across the state in terms of what courts are doing. So that we issued a first report that just looked at how are courts responding to the initial slew of emergency orders and sort of the existence of COVID. And what you saw was a real smattering of courts across the state. Some were open, some were closed, some were doing things remotely, others weren't. Most courts were not actually issuing writs or evicting people, but some were accepting filings, others weren't. And so I think that this just speaks, and this is worse in places like Georgia, where we have a decentralized system, but a real fragmentation in terms of, which leads both to inconsistency in how things are being addressed across the state, but also real confusion for people who are trying to figure out how to navigate this, especially because depending on where you get your information from, things may be operating totally differently in your county. What's interesting, both with that data, but also more recent data that Appleseed has collected and we've been looking at, is that the lines don't often split cleanly across rural and urban. So I do think that we've seen some trends in the more recent data, which is looking at, how are the courts. Well, the data was collected in August. So at the time, the question were, how are courts responding as they begin to open up? Of course, there's been so many developments in this space with, the CDC moratorium and there have been a lot of stopping and starting. So I think things are still in this, to some extent, in a holding pattern. But, unsurprisingly, I think there's some courts in metropolitan areas, I think, are a little bit more likely to be dealing with backlogs and, allowing remote filings, doing things. But there's still just a lot of variation in what each county is doing, and it's hard to find clear patterns among them.
Yeah, I saw you speak on the ABA panel this summer during the annual meeting when they talked about this legal deserts issue. And if my notes were correct, one of the things you said then was that something interesting that you found is that rural courts are much more likely to put a premium on procedural justice, I think is the way you referred to it, whereas more urban courts are maybe more focused on moving cases more quickly and not spending as much time on cases, but that there isn't necessarily a correlation between uh, you know, spending more time on a case and a better outcome for the case. Did I get
So I
that
think that's
right?
right. Well, yeah, I don't know if I'd put it in terms of time, but you're right as to the overall point. I mean, one of the things that's been so interesting about doing this research is that's really pushed back on some of the assumptions that I think we as the legal profession make, right? So often I think the courts that tend to be villainized when people in access to justice talk are these, large urban courts that, do assembly line justice, right? They just
Right.
process cases in mass. And I've seen in
Right.
Fulton County, people essentially get evicted en masse, right? They're all
Right.
told on the pleadings, they have no defense.
Right.
You're
I
out
guess
in
that's
seven
where the
days.
time issue came into my mind. I'm thinking,
Right.
are you moving cases quickly, in an assembly line fashion, or are you spending more time on each case separately?
Well, and I think to some extent the timepiece is there, and that one of the courts that where we did some research, unlike larger courts, which of course have different pressures because they have big caseloads and they have a lot of volume to get through. One of the courts where we studied, the court scheduled hearings individually for a half hour, so they were literally getting probably more time than you would if you were in a larger court. And also what we saw, and when speaking to the judges, especially in the smaller courts, really seem to put a lot of importance on this idea of giving tenants their day in court, letting them feel heard. So, I think my colleague and I, in observing this, thought, well, this feels like a much better experience, right, for people. They're
Yeah.
getting to actually tell their story. I think the problem is, and you're right that didn't correlate necessarily with better outcomes for tenants. And I think part of why that is in Georgia, landlord tenant law is not very favorable to tenants. And so I think to some extent, the more likely you are to get a full hearing on the merits, it may not actually be helpful for you because at the end of the day, right, the law doesn't give you a lot to work with. And I think another problem is that we as sort of a system, the courts haven't done a really good job of helping tenants to figure out what information is relevant and what isn't, right? So often tenants will come in and want to tell their story and they don't realize that everything they're saying from the view of the courts is not relevant. Right? A lot of times what all the court wants to know is, did you pay your rent or not? Um, and yes, it's true. If you didn't pay your rent, at least in Georgia, you don't have a defense. But there might be a lot of other things going on in that case, right? Things that the landlord failed to do. The landlord does still have some duties, even under Georgia law. And when we spoke to some of the lawyers that do this work, they said that they had a lot more success with raising counterclaims, which are claims that the tenant can raise, not necessarily in defense, but in response to some of the things the landlord has failed to do. But tenants, to go in and they say, I've lost my job, I can't pay, just sort of looking for more time or looking for some grace, and they don't get it because that's not how the law works. And I think another assumption that we saw tested is that I think you often think, well, a tenant should file an answer, right, which is in response to the eviction notice. Seems like you should do that. Partly that's part of the process, and you'd
Hmm.
think that that's going to give you a better shot. I think often people say, at the very least, it will buy you time, right? So the tenant should file an answer. Well, one thing that we saw in the data was that the filing of an answer actually made it there were cases in which answers were filed were actually more likely to end in a writ, and there was no delay gained by filing an answer. So I think that this, we're teasing that out as we write the article, but I think it goes to this broader point that we make a lot of assumptions about how things work
Right.
in the system without really knowing how they play out in practice. And the reasons why they play out that way may be complicated. It may be that there is some truth to our assumption, but if it's not operating that way in practice, we need to be really careful about the advice that we're giving people, or at least making sure to qualify that advice appropriately. Otherwise, we're actually sending people into a situation worse off, perhaps, than they would have been otherwise.
So we need more data.
Yes, we need a lot more data, particularly on, I think, people's experiences, right? What
Yeah.
actually happens on the ground, and that's partly what we're trying to do with this study is not just look at. Often what I think people think about is, how many evictions were filed and how many people got evicted. There's a lot that happens in between those 2 points. And so part of what we're trying to understand is what does that, we coded every detail of that process, trying to figure out where are things going wrong? Right? Where are the gaps? What's happening? We talk to people to try to figure out how are they perceiving the process. And I think you see that people think about it very differently from different angles. And so it's a much more complicated picture than just two data points.
Yeah. Something else I wanted to ask you quickly about. I realize I've spent more time on this topic than I had planned to, but you've written a couple of articles over the last year or so on this sort of the split between civil and criminal, the concepts of civil and criminal access to justice. I mean, you talk about the fact that we tend to think of civil justice and criminal justice as in separate silos, but that maybe that's not the right way to think about it. Can you talk about that a little bit?
Sure. So yes, we do think about them very differently, right? I often say that we think about them as two different silos, and almost everything in our system is organized around those two silos. The problem with that is that people don't necessarily experience problems in that way, right? So
Right.
when somebody has a problem arise in their life, it doesn't come neatly packaged with a label stuck on it, nor does it exist in isolation, right? So people have problems that arise in this sort of overlapping, interacting way, and we expect them to be able to sort that out and navigate a system that does not operate that way at all. I mean, the two parts barely even talk to each other. And part of what I'm grateful for about my own experience and how I've approached this research is that I'm often the person in discussion with a bunch of people who do civil work with some criminal experience, and I'm
Yeah.
often the person on the criminals, with a bunch of other sort of defense oriented people or criminal people who has some thinking going on about how the civil system operates. And it's just interesting to me how little people in either of those spaces think about the other space. But another issue from sort of a doctrinal or procedural perspective is that we've separated these things, but in practice, the silos are actually not that separate. And I'm not just referring to how things arise in people's lives, but also, right, civil sanctions can be punitive. You can be incarcerated for things that are civil matters. And likewise, on the criminal side, as we know, there are a lot of financial penalties and sanctions that are imposed for criminal behavior. So there are plenty of examples that I talk about in a forthcoming book chapter of things. I think it's harder to label things as civil or criminal anymore. The lines have gotten blurry, yet we live in a world of law where a lot flows from getting that label stuck on you, right? There are a lot of procedural protections, whether it's the right to counsel or other sort of evidentiary, rules. A lot flows from that. And so we've come up with this situation that cares, or a system rather, that seems to care a lot less about how things operate in practice than it is interested in labels. And for me, that doesn't make sense. Because again, I'm very pragmatic, so I want things to
Yeah.
sort of make sense. But more, also troubling is that that's just not how these issues come up in people's lives. And so I think it makes it really difficult to address someone's issue when you can't address both, the combination of issues that they're dealing with at the same time.
Yeah. And does that become an impediment to reform? I mean, if you have one group of reformers focused on civil justice and one group focused on criminal justice, do they get in each other's way?
I think, I hope not, but I do think, I've been in plenty of conversations where I feel like each side sort of thinks they have it worse, right? The criminal side said, well, we have a constitutional amendment backing up our, stuff. So, and that's not even being met. Whereas on the civil side, they say, but we don't even have the constitutional amendment. We don't have a right to counsel. And there's plenty of problems to go around, right? I don't think that these sides are at each other, but I do think, one example of maybe how we're not thinking outside the box enough is the push for decriminalization on the criminal side often just pushes things into the civil box, right? So all we've done is change the label, but then we've just attached a different set of problems, right? I think that maybe how we need to think about some of these issues is not in the context of decriminalization, but delegalization, right? Maybe we just need to get these things out of the system altogether, as opposed to just pushing things from one part of the system to another, where because you do lose a lot of the procedural protections once you've gone over to the civil side. So and not that I'm saying I'm opposed to decriminalization. I think there are plenty of things that don't need to be criminal. In Georgia, our whole traffic code is criminal. I'm not sure that that's necessary, right?
Right.
But yeah, I think we need to sort of think about how these two sides are interacting with each other and thinking about it from a broader perspective than purely just operating within one sphere.
Yeah. So what is your experience working and studying, doing research in this area taught you in terms of whether we're making progress and what we should expect for the future with regard to access to justice? Are you hopeful that we are bridging the gap, the justice gap that we so often talk about? And how are we doing in that score?
Well, that's a big question.
I know.
um, I don't know. I think I'm both optimistic and pessimistic, right? So I think people, it feels like more people are paying attention to this issue, or especially just in light of all sorts of recent events, even though they're not directly tied to access to justice in the way that I think about it. But there's been so much, right, sort of unrest and sort of heightened awareness brought to certainly racial issues, which of course have always been there, but it feels like events of the last year, months have been sort of pushing that to the fore.
Yeah.
So I feel like people are maybe more sensitive or in a place that they're willing to talk about these issues in a way that maybe they weren't before, and that's always a good thing. Um, I guess where I'm, pessimistic is, yeah, I don't know whether sort of people who have the power to make change are as convinced of some of that importance. But the other piece is, are we asking the right questions? And it sort of goes back to something we talked about earlier, which is I often think, and I'm guilty of this too, that we don't think enough about a lot of these things from the perspective of the people who are actually impacted by the system.
Mm-hmm.
Or we often have a lot of these conversations among academics and policymakers and lawyers and people who I think people may have different personal experience, but I think in a lot of situations people don't know what the system looks like to people who are really unfamiliar with it, and that's the majority of people who are actually in the system.
Right.
So I think if we spend a lot of time crafting reforms without that in mind, they ultimately won't be as effective as we want them or need them to be.
Yeah. I mean, there's certainly been a school of thought that believes that this pandemic that we found ourselves in for the last 7 months has perhaps can turn out to be a positive thing in the sense of enhancing access to justice, because it is teaching legal professionals of all kinds and courts of all kinds to use new methods of reaching the populations that they deal with, whether it be technology or otherwise. I guess mostly technology. Does that make any sense to you? Do you think, are you seeing any evidence of that?
I think that's true. I think, a lot of people, for example, going back to technology, have talked about how this actually has the potential to make a lot of systems more open, right? And maybe people are actually on a level playing field. I've heard some, I don't know if it's empirically supported, but evidence or at least thinking that if you have, people presenting both sides of a case via Zoom, might be more equally positioned than they would be if things were playing out in practice or in reality. So maybe it does have this sort of ability or potential to broaden access and be an equalizer. But I think we also have to think about what's lost in that process. I think every time when you develop these solutions in technology, you're baking certain assumptions and things into the system that are the same things that, at least in practice, when there are lawyers involved, you would hope that those lawyers can challenge, right? If everything's sort of baked into a ready-made algorithm or app, that's controlling the arguments that people can or can't make. And so that may be leaving out certain, because I'm being a little abstract here,
No, it makes
but I think
sense.
that may that may eliminate the potential to really change the system in a more fundamental way. So you sort of gain maybe better access in the short term, but longer term, if you zoom out, you've maybe lost some ability to create more structural change.
Right. Treating some of the symptoms instead of the disease.
Right.
Well, Lauren, I've been asking you a ton of questions. Is there anything else that you wanted to talk about, or any closing thoughts before we wrap up?
I guess just one other point that might be worth mentioning, right? We started talking at the beginning about rural justice and legal deserts. And one thing that I've been thinking a lot about in the context of my research and in talking about these issues is, right, and you asked about this as well, what is the solution? And I think I think there are some things that you can certainly implement across the board, and they're probably a good idea everywhere, right? But I think there are other things that it's not such a bad thing if they are different from jurisdiction to jurisdiction. And one of the lawyers who we interviewed for the project, I think, said, that judges are going to do whatever they want to do anyway, and there's no way. They didn't say this, but there's no way we can sort of know what's going on in all places at all times. And she kind of questioned whether uniformity was really the goal here. And I think that's also an interesting thing to keep in mind. And part of what I think about and thinking about what do access to justice solutions look like everywhere. I think we should be careful of mandating that the solution is the same for everyone, but instead maybe be more thoughtful about what solutions work best in what types of places, and that the best solution in Atlanta might not be the best solution for rural Georgia.
So there are cultural contexts to addressing these issues as well as systemic ones.
I think that's true. In the article, we talk a lot about this idea of legal culture, right? And that there's law, but then law sort of adapts and changes based on the people who are implementing it and the place in which it's implemented. So I think the same has to be true of the solutions.
Lauren, I really appreciate your taking the time to talk with me today. It's been really interesting, and it's been great to have a chance to speak to a fellow Massachusetts native.
Well, thank you again. I've really enjoyed the conversation, so thanks for having me.
That does it for today's show. Thanks again to Lauren Sudeall for taking the time out of her busy schedule to be with us. Thanks, as always, to Populous Radio for producing and editing today's show. And thanks to all of you for listening. Until next time, this is Bob Ambrogi.